Hey everybody. Good evening. Good evening. I come back to give you guys some update on Boosie's case. As you all know, on the 13th of this month, he will be back in court at the San Diego Federal Court building. Before he goes to court, his attorney did file a motion to compel that the government submit Brady um, evidence. So we're going to go over that right now. All right, let's go. Let me just bring this up. All righty, let's go ahead on and get to. All right. This is the motion that his attorney submitted in for Boosie in regards to his court case coming up on Friday. Let me make this bigger. Hold on a second. Just 1 second. Okay. All right. It says here, United States of America plaintiff versus Torrance Hatch defendant. Case number 323 CR 01201 CAB. And this is basically reply in support of defendant's motion to compel discovery. Mr. Hatch, by and through undersigned counsel, is requesting that the Honorable Court compel the United States Attorney's Office to produce all recorded communication between the United States Attorney's Office and or its agent and the San Diego County District Office and or its agent as it relates to the prosecution of Mr. Hatch. These recorded conversations would serve two purposes for the defense of Mr. Hatch. One being that the investigation into Mr. Hatch was shabby and unreliable. And the second being that the current prosecution of Mr. Hatch is the result of prosecutional vindictiveness. I got tongue-tied. Vindictiveness, and as such, a violation of Mr. Hatch's due process rights. A. The request is not vague. The government has objected to Mr. Hatch's request for discovery as being immaterial, overboard, and vague. The request is specific. Defendant is seeking all recorded communications between the United States Attorney's Office to include its agent and the San Diego County Attorney's Office to include its agents regarding prosecution of Mr. Hatch, as Mr. Hatch has been charged in San Diego County the one time. This request should not be overbroad or vague. Further, the request is not immaterial, as will be discussed thoroughly. Okay. So basically, they I guess they originally replied saying that the request that Boosie's attorneys had was vague and and was basically not necessary. But they're telling them back here now, hey, we need to have this. This is not vague. It's very important to our case. We need it for the defense of Mr. Hatch. And also, there were some things that was done in the communication, which was like basically bias to Mr. Hatch. And they had said some things, and they want to reveal what was said during those communication, what bias and nasty things that they said against Mr. Hatch, because they trying to keep it a secret now, but it needs to be brought out because it's part of the Brady. Because they'll be in violation of Brady because they're supposed to bring all things, whether it's favorable or not, towards the defense, so they can fight a good fight for their client. Hold on a second, y'all. My thing stuck underneath my wheel of my chair. Lord have mercy. Hold on, y'all. My cord is stuck in between the chair. I got it. Sorry. Sorry, my cord got stuck in between my chair. I'm trying to charge my phone. All right, let's continue. All right, the discovery sought is discoverable under Rule 16. The requested discovery is discoverable under Rule 16A 1E, which states, upon a defendant's request, the government must permit the defendant to inspect and to copy or photograph books, papers, document, data, photograph, tangible object, buildings, or places, or copies, or portion of any of these items if the items is within the government's possession, custody, or control, and the item is material to preparing defense. The government argues that the material requested is exempted from discovery by the defendant pursuant to Rule 16A2 of the Federal Rule of Criminal Procedure. In support of this argument, the government cites United States versus Zone. Gave us a case law in that. In Zone, the defendant filed a motion to compel discovery of weekly meeting notes after task force composed of federal and state agency, wherein the agency would discuss and coordinate participants' activity in a task force to end gun violence. In each case where the federal and the county prosecutors both claim jurisdiction over a gun-related offense, the task force would make a strategic decision where to prosecute it. In Zone, the defendant was requesting discovery to support his claim under the Double Jeopardy Clause, pursuant to Barkus versus People of State of Illinois. The case number is there. The Ninth District Court of Appeal affirms the district's court denial of defendant's request for meeting notes, not because they were exempted from Rule 16A2, but because the defendant failed to satisfy the requirement of Rule 16A1E. To obtain discovery under Rule 16, a defendant must make a prima facie showing the materiality United States versus Zone, and then the case number in that, citing a United States versus Mandel case number on that. The court reasoned that because the defendant failed to make a prima facie showing that the federal and state agency colluded rather than merely cooperated together. Another case the government cited in support of their argument that the Rule 16A2 exempts the requested material from being discoverable was United States versus Lucas. Gave a case number to that. The fact of Lucas are similar to those in Zone, and so is the holding. The defendant in Lucas was arrested and charged and tried in California state court and convicted of being a felon in possession of firearm. Days before his sentencing in state prison, concluded that federal government filed charges stemming from the same act. The defendant filed a motion to compel discovery of, amongst other items, all letters, emails, memoranda, or other existing documentation showing the point at which the federal authorities became aware of the state prosecution against Mr. Lucas, and what communication occurred between federal and state authorities, and when they occurred and why initiated them, in order to show that the federal and state agency colluded in the prosecution of him. He gave a case law on that. The Ninth Circuit Court of Appeal held that the defendant in Lucas could not get the requested material because he did not make material showing he did not make a material showing as required Rule 16A1E. In the Lucas court held, subject to exemption described in Rule 16A2, Rule 16A1E requires that upon defendant's request, the government must disclose any document or other objects within its possession, custody, or control that are material to preparing the defense. To obtain discovery under Rule 16, a defendant must make a prima facie showing of materiality, ab site zone supra. The low threshold of materiality is satisfied if the information requested would help the defendant prepare a defense. Gave a case law on that. Cited in of United States versus Jimenez Menza. Neither a general description of the information sought nor collusory allegation of materiality suffice. A defendant must present facts which would tend to show that the government is in possession of information helpful to the defense. Gave a case law on that. However, a defendant needed spelled out its theory of this case in order to obtain discovery. Nor is the government entitled to know in advance specifically what the defense is going to be. The relevant subsection of Rule 16 is written in categorical terms. Upon defendant's request, the government must disclose any documents or other object within its possession, custody, or control that are material to preparing the defense. Federal Rule of Criminal Procedure 16A1EI. Unlike the preceding and subsequent subsection, which both requires the government's knows or through due diligence could know that the items exist, subsection E is unconditional. Lack of knowledge or even a showing of due diligence wouldn't excuse non-compliance. United States versus Hernandez Menez. In thus who behooves thus behooves the governments to interpret the disclosure requirement broadly and turn over whatever evidence it has pertaining to the case. ID at 768-69. Citing to United States versus Lee Del Carmen, cited case on that one. Yeah, editor, Beyond the Brady Rule, New York Times, May 19, 2013, at SR 10. In the United States versus Galilean, as alleged number of Al Qaeda was indicted in 1998 and charged with conspiracy with Osama bin Laden, and other to kill American abroad. An arrest warrant promptly issued, and some years later, the defendant was captured abroad and turned over to a Central Intelligence Agency. ID. Rather than execute the arrest warrant issued at the time of the indictment, the executive branch held Giuliani in CIA custody. ID. Much later, he was transferred to secure facility at the United States Naval Base in Guantanamo Bay, Cuba, where he remained until he was turned over to civilian authorities in 2009 and presented pursuant to the warrant ID. Giuliani filed a motion to dismiss the indictment based on violation of his Sixth Amendment right to a speedy trial, ID. To assist in his defense and ultimate dismissal of the indictment, the defendant filed a motion to compel the discovery of any and all communication and or discussion, included but not limited to letters, emails, and or memorandum between the CIA, the FBI, any other intelligence agency, the Department of Justice, including but not limited to the United States Attorney's Office, the executive branch, included but not limited to President Bush and or Obama as applicable, Vice President Cheney and or Biden as applicable, the Attorney General and or / the Secretary of Defense, related to 1, the decision to transfer the defendant to a CIA black site after his arrest, rather than to the Southern District of New York, SDNY, for prosecution. 2, Guantanamo Bay, Cuba, rather than SDNY, for prosecution. 3, the decision to prosecute the defendant in a military commission at Guantanamo Bay rather than in the SDNY. 4, the decision to prosecute the defendant before an Article I court rather than an Article III court. 5, the decision to prosecute the defendant in the SDNY rather in a military commission. And 6, a decision to prosecute the defendant before an Article III court rather than an Article I court. The defense later narrowed that request to responsive document that all in the possession, custody, or control of the Department of Justice, and that indicates that the government's reason to delay Mr. Giuliani instant prosecution was a reason other than the interest of national security, as described more fully in the government's response and to defendant's speedy trial motion. The United States Southern District of New York found that any communication among pertinent government agency and official tending to investigate the reason for delay in prosecuting Giuliani on this indictment was other than the interest of national security described in the government's response would be material to the defense because they would undermine the government's speedy trial motion position as to the reason for delaying this prosecution. The court held that Rule 16A1E required that the government disclose the documents to the defense, and that if the government claims that any responsive document requires to be produced by the decision was protected from disclosure by Rule 16A2. It was to serve and file a log enumerated these document and providing information that would be required by the local rule in respect of the document withheld on ground of privilege, ID at 372. However, the privilege derived from the work product doctrine is not absolute. United States versus Noble. Okay. That's a case law on that one. Let me go down. Let's go down to a bunch of case law. All right. The advisory committee notes make clear that the committee believe that other rules of law may authorize or require discovery not mentioned in the rule. CEG Advisory Committee notes on Rule 16, 18 USC, App P 761. Rule 16 is intended to prescribe the minimum amount of discovery to which the party are entitled. It is not intended to limit the judge's discretion in order to order broader discovery in appropriate cases. Here, Mr. Hatch is claiming prosecutionary vindictiveness as part of his defense. Mr. Hatch motioned to compel the discovery of all recorded communication between United States Attorney's Office and the San Diego County Attorney's Office regarding the prosecution of Mr. Hatch is material to the defense that Mr. Hatch is being prosecuted vindictively. The fact which tend to show that the government is in possession of information helpful to the defense of prosecutional vindictiveness are the following. 1, the complete refusal by the San Diego County Attorney's Office to make Mr. Hatch an offer on the felony in possession charges in state court, ECF number 38, declaration of Damian Alamari. 2, the San Diego Deputy County Attorney's Office comment to Mr. Hatch's defense counsel that he had not made an offer to Mr. Hatch because he did not like Mr. Hatch for the reason that he came into San Diego from another jurisdiction, allegedly committed a crime, and then led his fan to in a fuck It led his fan in a fuck the San Diego police chant. EC number 38, Declaration of Deman Alimari. Mr. Hatch, defense counsel, witnessed the San Diego deputy county attorney smugly grin and say to Mr. Hatch, "So long," after the judge morning offer. Mr. Hatch is non-custodial deal. ECF number 38, Declaration of Deman Ali Mairu. Number 4, on the day Mr. Hatch was in state court filing out of his change of plea form, the San Diego County Attorney's Office moved to dismiss the charges against Mr. Hatch. Moment after ATF agent arrested Mr. Hatch and charges stemming from the same alleged incident were filed in federal court. ECF number 38, Declaration of Deman Alamaru. Mr. Hatch has made the requisites prima facie following all materiality under Rule 16A1E, and the court must compel the government to make such communication discoverable. C. Evidence of shabby investigation and exploratory evidence and must be produced pursuant to Brady. In its opposition, the government contends that the defense is attempting to utilize Brady as a fishing exposition and a pretrial discovery tool. However, Mr. Hatch has a very narrow request of discovery, which he is claiming he is entitled to pursuant to Brady. The request for all communication between the United States Attorney's Office and the San Diego County Attorney's Office related to Mr. Hatch, which not be extensive as this present case is the first and only criminal case Mr. Hatch has in San Diego County. The requirement of due process obligate a prosecutor to disclose material exploratory evidence, Singh versus Punity, favorable evidence in material and constitutional error results from its suppression by the government. If there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. United States versus Bagley. Here, the requested discovery is material for two different avenues of relief for the defendant. If the requested discovery illuminates the hasty course and low quality of the investigation into Mr. Hatch in the present case, then it is material and exploratory material as such must be made discoverable to Mr. Hatch. Kyle versus Whitley. If the requested discovery reveals prosecutorial vindictiveness, then it is material. A claim of prosecutorial vindictiveness is a claim of a due process violation, and there is a reasonable probability that if the evidence is disclosed to the defense, the charges will likely be dismissed. For this reason, Mr. Hatch is entitled to the requested discovery under Brady and its prodigy. Conclusion. For the foregoing reason, Mr. Hatch respectfully requests the court compel the government produce the requested discovery by Mr. Hatch pursuant to Federal Rule of Criminal Procedure, Due Process, and Brady, respectively submitted Damon Alamarui, attorney for defendant. All right, that was it, guys. That is what was submitted for Mr. Hatch, which is AKA Boosie. Anybody have any question? I gotta make this thing smaller. Hold on a second. I gotta make this thing. Why does it look so weird? There we go. Anybody have any question on that? Any question? No question? My throat is itching. Hold on. Let me mute myself. Hey, tall guys, I'm going tomorrow to the post office to send off your stuff. Any question, anybody? No questions? All right, so on the 13th, Mr. Hash, aka Boosie, will be in court. I guess everybody's sleeping. Everybody not interested in you in this. Okay. Well, I'm about to go. Y'all act like y'all so sleepy or something. I don't know where the folks at in here. But anyway, good people, I'm going to say good night. I just wanted to read this information to you guys. So I'll see you tomorrow. Have a great night. Bye, everybody. Y'all wake up. Bye.